Hey guys, here we go. There we go. Hey guys, it's your legal bestie attorney Simone. Let me know if you can hear me. Here we are. Hey guys, it's your legal bestie attorney Simone, and I am back today. We have an update. The judge has made a bail ruling on Diddy's motion to reconsider bail, right? Ooh, I've already seen some of the topics in the chat. Some people, there you go. Some people are feeling that perhaps something sinister is going on behind bars. I'm going to break down what this bail ruling means, what it means for potential sentencing, as well as Gina, victim number 3, submitted a letter to the court just yesterday. How does all this play into what ultimately is going to happen to Diddy regarding sentencing? Hit that like, hit that subscribe as you come on in. And also, don't forget, you can always book a consultation with me, your legal bestie, attorney Simone, at simoneredwine.com. There you go. That is my website right there. You can go there. You can scroll down, or at the top right, you can click book Simone, and you can do a consultation start at 30 minutes. And for 30 minutes, they are $200. I would love to help. I'd love to help any way I can. Now, Gina. Here's what we're going to start with. We're going to start with this bail ruling and what it means. So, Judge Aaron Subrahamian, I'm going to call him Judge Aaron. Judge Aaron was not playing. And I have to say, there's not really a surprise here. It's only 2 pages. So I'm going to hit the highlights for you guys here. And here's what the judge is saying. Now, to let you know, the main arguments, before I read this, I just want to recap the main arguments from each side. Those arguments were as follows. Basically, Diddy's side had said, hey, there are 2 things that we have to show under the law to be able to get the court to be able to rule that he can be released pre-sentencing. We have to show that there are exceptional circumstances, that there are exceptional circumstances that apply and that he is not a danger or flight risk. For the exceptional circumstances, what they did was they outlined very, very thoroughly. Diddy's team outlined basically the racist history of the Mann Act. That is absolutely true. It was created basically to punish Jack Johnson, who was a Black boxer who married a Caucasian lady. And so they created a crime to take a woman across state lines for sex. She was his wife. They were intimate. In turn, they were able to penalize him, punish him, take away his awards, and so forth. So that's how come people reference the Mann Act being rooted in racist laws and racist thinking and concept. Here's what's also super, super important to think about with the Mann Act. Jack Johnson, the boxer where that happened to him, Trump pardoned him what's called posthumously. I'm mispronouncing it, but after his death, Trump just pardoned him a year or 2 ago. I think it was in 2018, actually, during his prior presidency, because Trump felt that that law was so unjust and that he should not have been stripped of his awards and that he should not have been punished. So even after his death, Jack Johnson, the person for whom the Mann Act was created, Trump pardoned him. That was before any of this Diddy stuff. Let me know what you think in the chat. Do you think that is a signal? Do you think that is a signal as to how Trump feels about this law? Absolutely, about how Trump feels about this law. It was 2018. Yep, that's correct. It was 2018 that Trump, as we say, posthumously, which is after death. And I'll share that photo with you here. Yeah, he was not playing around. And of course, that was one of those things that I feel like Trump did because his term was coming up. He knew that, there we go. He knew that he needed to secure the black male vote. Remember, keep this in mind, the black male vote. Trump got a substantial number of that. And he knows that, no, he's not supposed to be able to run again. But at this point with America, who knows what's about to happen? But this, I believe, was a great signal to Diddy and Diddy's team with respect to the potential of a pardon. And before I do read the judge's response, I'm going to play this clip for you real quickly. This is Trump's direct response when asked last week whether he was considering a pardon for Diddy. And this all goes together with this bail issue.
Consider pardoning him.
Well, nobody's asked. You had to be the one to ask, Peter, but nobody's asked. But I know people are thinking about it. I know they're thinking about it. I think some people have been very close to asking. First of all, I'd look at what's happening, and I haven't been watching it too closely, although it's certainly getting a lot of coverage. I haven't seen him. I haven't spoken to him in years. He used to really like me a lot, but I think when I ran for politics, he sort of, that relationship busted up. From what I read, I don't know. He didn't tell me that, but I'd read some little bit nasty statements in the paper all of a sudden.
You see, that's what matters to him. If you say nice things about him, he'll consider a pardon.
You know, it's different. You become a much different person when you run for politics and you do what's right. I could do other things, and I'm sure he'd like me, and I'm sure other people would like me, but it wouldn't be as good for our country. As we said, our country's doing really well because of what we're doing. So I can't, it's not a popularity contest. So I don't know. I would certainly look at the facts. If I think somebody was mistreated, whether they like me or don't like me, it wouldn't have any impact on me.
He lying about that part. Whether they like me or don't like me, it would have no impact. That's not true. Here's what matters though. In the breakdown for Diddy's lawyers, as far as why he should be released, the main thing is that they said is, look, the Mann Act, as stated, one, it has racist backgrounds, and two, it wasn't created to police threesomes among boyfriends and girlfriends. This was supposed to be used where there was commercial sex, in other words, like a pimp or John who was bringing a bunch of girls across state lines to make him money, etc. It wasn't to be used in this instance. That's what his team was saying. And then the prosecution relied on the same arguments that they made on the day of sentencing. I'm sorry, on the day of the verdict. Those arguments were like, hey, under the law, it's mandatory. There's a specific provision under the Bail Reform Act that says if someone has been found guilty under Section 117, and that includes the Mann Act, that includes the one provision that Diddy was found guilty of, that they have to remain locked up, incarcerated until sentencing. But there's also a really important distinction that most people are not talking about, which is this. In the majority of those instances where someone is given bail before sentencing, those are all cases where they were already out on bail. I pulled the cases that were cited by both sides here. Every single case where someone was given bail pre-sentencing, they were already out on bail. It was not a situation where the person had no bail, was locked up, was found guilty, and then for the first time given bail. So that's distinctly different. So bottom line, here we go. So let's get into what the judges said and why. All right. So the key here is he renews his request for this bail sentencing on his application. He doesn't contest that detention is mandatory for his crime of conviction. Instead, he knows, in other words, Diddy knows it is mandatory for this crime. He relies, though, on the limited exception to mandatory detention under two situations where, quote, the court finds by clear and convincing evidence, that's basically 75%, 80% of the evidence, that the person is not likely to flee or pose a danger to the safety of any other person or the community if released, and that there are, quote, exceptional reasons why this person's detention would not be appropriate. The court says exceptional reasons exist where there's, quote, a unique combo of circumstances giving rise to a situation that are out of the ordinary. This framework creates a presumption in favor of detention. As for the risk of flight or danger, the court says Combs fails to meet his burden by clear and convincing evidence. Clear and convincing is it's not quite beyond a reasonable doubt. It's not that far over, but it's basically about 80% of the evidence, 75, 80% of the evidence, that level of weight. It says clear and convincing evidence for the reasons set forth on the record July 2nd. That was the date they found him guilty. It says specifically, there's an increasing the amount of the bond or devising additional conditions do not change the calculation given the circumstances and the heavy burden of proof that Combs bears. Quote, and the next it says, even if the flight or the danger issue was satisfied, there are no exceptional reasons warranting a departure from what Congress has required. I'll say this about the bond. Remember, they were willing to put up $50 million in bond. The court is basically saying, even that $50 million, it doesn't take away the risk of flight where someone is as wealthy as him. Here they're going to go into it some more. It says, even if the flight or danger requirement is satisfied, there are no exceptional reasons warranting a departure from what Congress has required. Combs's Mann Act arguments might have traction in a case that did not involve violence, coercion, or subjugation in connection with the acts of prostitution at issue. In other words, the judge is saying he believes that in connection with the prostitution, there was violence and coercion. That's interesting. It says, but with the record here, there contains evidence of all three: violence, coercion, and subjugation in connection with the acts of prostitution. While Combs may contend at sentencing that this evidence should be discounted and that what happened was nothing more than a case of willing, quote, swingers utilizing voluntary services of escorts for their mutual pleasure, the government takes the opposite view, that Cassie Ventura and Jane were beaten, coerced, threatened, lied to, and victimized by Combs as part of their participation in these events. That makes this case unlike any of the other cases that Combs points to and places it outside the narrow exception to detention that Congress otherwise deems mandatory. In other words, it's mandatory here because of the violence and those other things that the judge just referenced. The judge says, to be clear, as indicated in the July 2nd hearing, the court offers no view as to how the parties' competing arguments about the evidence will cash out for purposes of sentencing, which is happening in just 60 days. That's true. At this point, however, the record doesn't establish the kind of, quote, out of the ordinary exceptional circumstances requiring immediate release. Basically, what the judge is saying, hey, look, y'all, don't take my ruling here to mean one way or the other regarding how sentencing is going to go. We're not doing that. I'm not doing that here today. The reason why the judge would say that, and I do believe he's going to follow that, is the judge is going to lean on the probation's pre-sentencing report. In order to do that report, and it's not yet been done, the assigned probation officer is going to interview Diddy's loved ones, his family, his friends, his therapist. If he's in AA or Narcotics Anonymous and he has a sponsor, they're going to speak to his sponsor. They're going to talk to everybody. They may even talk to Gina. We'll get to that. They may also talk to anyone who wrote a letter in support of why he should be released and why they believe he is not a danger to the community any longer. It says Combs also points to squalor and danger at the Metropolitan Detention Center, conditions that he says have been aggravated by the federal government's aggressive budget cuts this year. The public outcry concerning these conditions has come from all corners, but as Combs acknowledges, MDC staff has been able to keep him safe and to attend to his needs, even during an incident of threatened violence from an inmate. So apparently, Diddy was threatened. by an inmate, and nothing happened to that inmate. That's because Diddy still has, that's also in part, Diddy has access to so much money that if Diddy wanted to pay others to protect him, he could do so. That doesn't mean that violence isn't an issue, because if you're being extorted to protect yourself, that's not okay. Here's interestingly, though, what the court then says. This is the court found, it says, the court found that the conditions at the MDC rose to the level of, quote, exceptional reasons warranting release in another case where it was undisputed that the defendant posed no risk of flight or danger and where, quote, unique circumstances counseled release, including that in that case, the defendant's advanced age and where there were advanced age and serious medical conditions which require care that the MDC may not be able to provide. Those facts are not present here, and nothing in the case of Chavez, that was the one where the guy was going to get beat up if he stayed incarcerated and they let him go because the threat of physical harm was a legitimate threat there. It says, and these facts were not present here, and nothing in Chavez suggests that exceptional reasons warrant release for every single person awaiting sentencing at the MDC. That is not what Diddy's team says. They did not say that at all. It says, rather, the MDC is one factor, admittedly a serious one, to consider along with others in making the determination. For these reasons, as well as those stated on the record on the July 2nd hearing, Combs fails to satisfy the burden to demonstrate an entitlement to release. The motion for bail is denied. Did y'all know that it appears Diddy was threatened with violence by another inmate? I did not. That's my first time hearing or seeing about that. It says, why didn't we hear about this serious medical condition during the trial? No, Diddy's not saying, the court's not saying Diddy has a serious medical condition. What they're saying is Diddy's team cited cases that listed exceptional circumstances for release. And some of those cases were cases that actually referred to the MDC where he's being located and basically said the conditions at the MDC were really, really bad. They're saying those cases are not like his case because, like you just said, he does not have a medical condition. Those, or one that is so severe that they do not believe it could be tended to at the MDC. The other thing that was interesting is, and it might be in the footnote, is that the case, so there was a case just last year. It was a case from January of 2024 where the court did allow a man to be released pending sentencing due to the dangerous levels of conditions there, as well as he was being threatened by another inmate. Well, in that case, though, the government is saying, hey, that's different because back in January of 2024, when that case came across the judge's desk, the staffing level at MDC was only 55%. Basically, they didn't have nearly enough staff to protect the inmates. Whereas today, they're stating that the staffing is at like 93 or 94% so that it's more safe. It says, Brandy said it well. Brandy says, not the inmates that were cheering when he came back from court. Is one of those the inmate that was threatening Diddy? Interesting, y'all. Hit that like as y'all come on in. Now, as I was reading this, and I also, of course, I read the both of the arguments, both from Diddy's team before this, as well as from the government. Let me show you something from the government's letter that I cannot get off my head. Now, I knew that this was going to come out just this way, right? Because this judge, I'll make this a little bit bigger. This judge does not play about the law. So on the day of the ruling, right, on the day of the verdict, immediately Maureen Comey popped up and she said, immediately Diddy's legal team, Mark, he stood up and said, Your Honor, we want him released today. We'd like to have a hearing today regarding bail. And the judge said, okay, we can have it this afternoon. And Miss Maureen Comey said, no, Your Honor, we're gonna go for 20 years. And I was like, girl, what? No, girl, don't do that. She's like, Your Honor, we're gonna go for 20 years. We need time to brief this. So the judge said, okay, brief it and come back at 1 p.m. because I think this was like 10 a.m. Now, I have to be clear. That was the only time she mentioned 20 years. 20 years is simply the max if you were to stack both charges. Even when she came back that afternoon, Maureen never asked for 20 years. They're actually going for about like 51 months to 63 months, which is around 6 years. Listen, but when she stood there and they did that, the judge said, "Well, Miss Comey, can you give me a case under the Mann Act where someone was not given bail?" And she said, "Oh, Your Honor, we have some cases, but I'm gonna need I'll need some time from this afternoon." So in that moment, I saw that the judge is like, "Just tell me what the law is, and I'm about to follow it." Remember, that's the thing about federal judges that are so different than state judges. Federal judges have lifetime appointments, which means, here we go. They're lifetime appointments, which means they don't sway based on public opinion because they don't have to worry about re-election. Even if they're appointed by a different president, like Trump can't take out Subramanian just because Obama appointed him. No, you can't do that. So the judge said, "Bring me a case this afternoon where someone was not granted bail under the Mann Act." Oh, excuse me. And the afternoon came, and they have now in their arguments, in their motions, provided cases where someone was convicted of the Mann Act and was not granted bail. But more importantly, what they relied on is that one provision under the Bail Reform Act that says he was sentenced under 117, therefore it's mandatory. And then the other thing that has come back to bite Diddy on his bottom, okay, not tossing the salad, biting the bottom, is that his entire argument and what got him out of the RICO and out of the trafficking was, "Hey guys, this is just domestic violence." So the judge is saying, you can't take the very argument that you made to basically be found not guilty and then be like, "Oh no, Your Honor, no, don't worry about that. I didn't say that." You got to stand 10 toes down. If this is domestic violence, when you needed that argument to be found not guilty of the 2 counts that were causing you to face life, then on those same 10 toes, you got to stand by it and you're going to have to sit. You're going to have to sit this out for a moment. But in the end, as I looked and as I read all of these, this was a really significant portion. Now, this is the government's argument. And when I read the government's argument, this was what the government submitted. Stay with me, all. The government submitted this argument to say, "No, no, no, Your Honor, you got to keep him locked up." I want to show you something really important that, and there's so many good influencers that are covering the Diddy trial and so forth, but this is one of those that lawyers, particularly, we get. Let me show you. I saw this and I thought, hold up, wait a minute. First of all, I saw redacted segments. And my first thought is, hold on, why is anything redacted in a letter about bail referencing a case that's already concluded? The case was in the public eye. As you know, I was there almost every day of trial, sitting in, watching the case. So I was like, what is it that they're referencing that's blacked out that, we can't see? Well, I'm about to show you. So in this paragraph, right after the block of blocked out facts, or the sentence says, "But the defendant's suggestion that he went several years without inflicting violence on another person simply is not true. The defendant did engage in acts of violence between 2018 and 2024." And then it goes on to highlight what those are. The reason it's blocked out is because it must have been something we didn't discuss at trial. The reason I say that is because if it was discussed at trial, they could block out like words. Here, they block out the whole thing. They don't want us to know who, what, where, any of that. And the next sentence, and there's a footnote, and then the sentence reads, "Although the evidence was not presented at trial, the court is free to consider it in assessing the defendant's dangerousness, quote, recognizing that proffers are permitted both in the bail determination and bail revocation context." Let me tell you what a proffer is. A proffer is when someone comes in to the feds, to the office with the feds. I've done this with my clients before. They come in and they're able to give an outline of the facts of what they experienced. And the feds say, "Whatever you tell us here, we cannot use against you. If we're going to use any of this, we would have to get separate third-party facts to substantiate whatever you said happened, but we can't use your words against you in this proffer. And then I look down at the bottom. And it says, the footnote says, defendant's counsel has been aware of these incidents since at least the time that the government produced Exhibit 3500. What this says to me is one of two things. It says to me, we didn't see certain evidence of violence, either from other witnesses that came in and did the proffer, which means they came in, they were king for a day, they were able to tell any and everything, and that the feds decided what they did and didn't want to use, or that Diddy and his legal team actually sat down with the feds and gave them facts and told them what was going on and what the real maybe they sat down and told them, hey, with Jane, here's what's happened. She hit me in the head. And then in retaliation, I immediately responded and I chased her through the house and XYZ. Stay with me, guys. Here's my thoughts. What I'm saying is, if in fact Diddy did a proffer with his attorneys, that means there was a point when he was trying to work with the feds. He and his legal team literally were trying to work with it. If in fact this proffer is referring to him, it sounds like it is. It sounds like these were facts that Diddy shared about situations he'd been in during that time frame, and that they blocked him out, right? Because it was not admitted into court, probably for various reasons. But I can see now in part why, if Diddy's legal team did sit down with the feds and try and get them to reason and try and get them to be like, hey, this is just some swingers, this is this and this, that, and the third. I can see why they were so frustrated and said, F it, this is ridiculous. The feds are being unreasonable. We're going to just put all 10 toes down and we're going to put all 10 toes down and we're fighting this to the end. Because let me tell you something. If I sat down with a client and my client told them, for example, about the Jane scenario, and remember with Jane did not get added until a month before trial. Jane's situation did not get added until April. Trial started May 5th. If I told them all that stuff and then they decide to add the Jane shenanigans, I'm like, oh, hell no. Because at this point, it's sounding like the feds are not being reasonable. They just want a huge win. So keep that in mind. It says that was, that is what the judge was talking about when the judge talked about violence up until now. One of the incidents that the judge was referring to was when Jane slammed his head into the countertop. So, wait. Mr. T asked, why didn't Diddy go to the cops when Jane hit him? He waited until she came back and he clobbered her. Well, I can tell you the reason he didn't go to the cops when she hit him is, number one, he's Diddy. What does it look like that this little dainty woman, that I have to call the cops on her? He could have, of course. But I think more importantly, scratch that he's Diddy. The fact that this is just a month after the Cassie video had come out. He'd settled with Cassie. He knows that the feds are investigating him. If I were him, I would have called my lawyer and said, this is what this crazy girl did. What should I do? And let the lawyers take it from there. Thank you. Thank you so much. 3,500 is the sealed enterprise letter. So what this is establishing, this little paragraph here is powerful. What it is establishing is that at one point, Diddy was in fact working with the feds to give them the information that they needed, in part to perhaps make a reasonable offer to him, but also to see that it's not necessarily what they were thinking. So for example, if he would have presented all that and they came back and said, all right, Diddy, we want you, we're going to give you an offer to plead to 2-man act charges. Depending on what the time offered would have been, I bet he would have said, okay, if you're going to take trafficking off the table and I do 2-man act charges, which is hookers, ain't nobody worried about no hookers. Nobody was worried about hookers, especially in light of the accusations that we believed were on the table. Remember, we're drugging baby oil and hurting children and so forth. So I say that to say, just keep in mind, it's interesting that there was a point, it appears based on this, when Diddy sat down And his legal team sat down with the feds and were trying to work with them. They were cooperating. They were giving them the information that they thought that they needed in hopes that they would come back with charges. And it was probably, for me, for my client, the minute they came back with that Jane charge, I'd say, oh, heck no. And no, that was around the time that Jane stopped responding to Diddy's attorneys' questions, because they were interviewing her. They were preparing and expecting that Jane would likely be subpoenaed or a potential witness. But I don't think that they were expecting, until he was in fact indicted under her, that she actually would have been a charge. Hit that like as you come in. Here's the other thing. I got to give props where props are due to good legal strategy, which I believe was this. KK and the security guard, right? D-Rock. I firmly believe that the largest part of why Diddy won, and I consider it a win overall, was because KK and D-Rock never flipped. And more importantly, it appears they did not sit down with the feds. They never did. Here's why I feel comfortable telling you this. As an attorney who's been doing this for almost 2 decades, one thing you know about any lawyer is we do not ask someone a question on the stand we don't already know the answer to. How would they prevent the prosecution from knowing the answers to certain questions that would have been asked to KK or D-Rock? Don't let them talk to them, or discourage them from talking to them. Now, I say discourage. I don't mean in a way that's like going outside of the law. Go ahead, hit that like button. But I mean, after Diddy sat down with them, because remember, that's what this proffer indicates. The fact that during a proffer, they got some facts of some alleged violent acts that Diddy did. And even after doing that, they wanted to proceed in the way that they have, right? After that happened, because imagine KK and D-Rock, they were represented by the same legal team. KK documents reveal that KK's lawyer is also Teeny Garagos during this whole process. So if that's the case, if I'm Teeny, I'm like, no, these feds are not being reasonable. I don't think you should sit down and tell them a thing. D-Rock, I don't think you should sit down and tell them a thing. Because I firmly believe that I was saying this throughout the trial, I felt that in order to slam dunk the RICO, they needed KK or D-Rock or both to take the stand and outline what was done. That never happened. That never happened. And I believe that is a key factor, because there was not sufficient evidence of how the enterprise worked. And in the end, what happened in the end? The jury did not find an enterprise. The jury found that there was distribution, because remember, they asked the judge, well, if a friend asks me for substances and I give it to him, is that distribution? And the answer that the court wrote back to was yes, and it doesn't require a sale, and directed them to that part of the jury instructions. It was at that moment when the jurors were like, hold on, wait a minute, that could have been me. That could have been me. I've had a friend, I got an Adderall prescription or something, and I had a friend who asked me for something, and I've given them two different times. That could have been me. The moment a juror sees themselves in the facts, you're going to get a not guilty. Nobody wants to sentence themselves. Nobody wants to sentence themselves. So with regards to the enterprise, they were then able to say, like, okay, well, maybe if he did 2 instances of distribution, what are the other elements required for an enterprise? Oh, that they're a criminal group and they work together and da, da, da. Okay, well, if we agree there wasn't evidence of that presented, right? Because there was no KK, no D-Rock, then they're able to say, no, we cannot find beyond a reasonable doubt that there was RICO. And that's how they work. Hit that like. So can KK and D-Rock, will they not be charged? I don't think they're going to be charged. I believe the only way they would have been charged is if Diddy had been found guilty. That's my personal opinion. Also, remember, now we don't even have Maureen Comey. There is a Trump appointee that's leading the department, but we don't have Maureen. And Maureen is the one that knew the facts up, down, left, right, side to side. The Trump appointee just got there, honey, in February, March. Because he didn't get there immediately. There was an interim acting person. So, yeah. So I say that to say this was all a strategy. Now, talking strategy, I'm gonna be very clear, and we're gonna talk about Miss Gina and then kind of wrap this on up. to be clear, don't get confused in the weeds. This is not about bail. This is not about bail. I mean, if he were granted bail, absolutely he would have loved that. But on the contrary, if he's not given bail, this is all about setting up a record where Trump has everything he needs to pardon him. So it's setting up a record where you're able to establish that this man, Diddy, has been railroaded by the government, has been treated unfairly under Maureen Comey and the, Biden administration hirees, that that a racist law has been used to incarcerate him. Remember, that is the Mann Act that was initially created for Jack Johnson, African-American man who married a Caucasian lady, who Trump then pardoned posthumously after he died, many, many years after he died, because Trump felt the law was so bad. Also, because Trump's base, a large part of his base is something like 10% of African-American men. That's why he continues to do things to support and to support that vote, including pardoning a bunch of rappers. So you got all this coming on in. Hit that like, guys. We've got less than 200 likes and we've got almost 700 in the chat. Yes, and a new USA will say we have bigger fish to fry. So I believe this is all setting up for the pardon, which is why Gina's letter was so appropriate. So Gina. So remember, Gina was victim 3. Gina was victim 3. And if you remember during the trial, I could not figure out for the life of me why they thought Jane was a good idea. But then as I thought of the facts of what they were supposed to be, thank you so much, Canberry. It says Trump said Diddy said some mean things and that he's not pardoning him. No, he didn't. There was actually a clip that I played earlier in this video. It's not that he said he's not pardoning him. He said he'll think about it. He said he said some mean things. He said he'll think about it. And then he threw in this line where Trump says, but even if the person doesn't like me, if they're treated wrong, I would consider it. I would consider a pardon. So really what I think it's going to come down to is millions and millions of dollars donated, more than likely. But also when he said, it wasn't that he's not considered pardoning him. It's that Trump's administration is advising him to go ahead and let the judge rule. And then based on that ruling, you'll decide whether or not it's a pardon. Here's why that makes sense. And thank you so much for that super chat. I would agree. If I worked in the pardon department, I'd say the same thing. This is why that makes the most sense. It's because if the judge gives him time served, there's no need to interfere in that, right? If the judge does not give him, let's say the judge gives him something more like 6 years. It's at that point, we now have this really strong record that's been created by Diddy's legal team that's outlined, the history of the racism of the act, the Mann Act, and all of these other things. So that way, there is some wiggle room there because, and remember, in the end, Trump still has a large female Republican base. And you don't want to upset these women by pardoning a man who appears to be abusing women. We still got that CNN video out there, right? That CNN video is still out there. So I'm going to play the clip because some people are like, no, Trump said he's not pardoning. I'm going to play the clip. So I may have heard it wrong. Here's the clip.
To The Apprentice, you mentioned once in 2012 that Diddy was a good friend of yours back then. He has since found himself in some very serious legal trouble.
Yeah, that's true.
Would you ever consider pardoning him?
Well, nobody's asked. You had to be the one to ask, Peter, but nobody's asked. But I know people are thinking about it. I know they're thinking about it. I think some people have been very close to asking.
Oh, you're right.
First of all, I'd look at what's happening, and I haven't been watching it too closely, although it's certainly getting a lot of coverage. I haven't seen him. I haven't spoken to him in years. He used to really like me a lot, but I think when I ran for politics, that relationship busted up. From what I read, I don't know. He didn't tell me that, but I'd read some little bit nasty statements in the paper all of a sudden. It's different. You become a much different person when you run for politics and you do what's right. I could do other things, and I'm sure he'd like me, and I'm sure other people would like me, but it wouldn't be as good for our country. As we said, our country's doing really well because of what we're doing. So it's not a popularity contest. So I don't know. I would certainly look at the facts. If I think somebody was mistreated, whether they like me or don't like me, it wouldn't have any impact on me.
All right. So yes, so I do see the update in here that over the weekend, he did an update and he said no, or probably not, that he wouldn't do it. I don't trust him. I don't trust him. And the legal team, there are members on the legal team that are in his back pocket, that are in his ear, that he listens to and respects, etc. So it could go either way. But I firmly do believe that as a backup, of course, the first goal was bail. But if they're not going to get bail, it's to create a legal record where ultimately the facts are there to justify a pardon. Listen, if you could pardon like NLE Choppa and Kodak Black and some of these people, like, there's some wiggle room there. Now, on to Miss Gina. Oh, God. Gina Huynh. I'm your legal bestie, Attorney Simone. I break down celebrity legal cases on social media and my YouTube channel here, Girl Is That Legal. And Gina Huynh has just risen from the dead. Gina was victim 3. Victim 3 was critical to this case because victim 3 was going to literally bridge the gap between the type of violence Cassie suffered and what Jane suffered. Because in Jane's situation, there was only one physical incident, and that was an incident that Jane acknowledged she initiated herself. So what appeared is that from basically 2017, 2018, Diddy hadn't touched nobody until someone aggravated him in 2024. That's what it looked like. Gina's position was to fill that gap. Let me show you a real quick clip of Gina discussing the violence that she experienced with Diddy.
We was upstairs and he had like, we were in his closet and he like pushed me and I fell to the ground and then he like stood over me. So I was like laying on my back and he stood over me and he started like punching me like this. Like he avoided my face, but he like started punching me like on the side of my head and I was just like covering my face. And he did that and then after he got done doing that, he like, cause he was standing, his legs were like in between me. So he stomped on my stomach like really hard and I like took the wind out of my breath. I couldn't breathe and he kept hitting me and I was like pleading to him like, can you just stop? I can't breathe. And he like stopped for a little bit. He like grabbed my hair from the back and like was like punching the back of my head because he was just avoiding my face when he was like hitting me.
All right, so that's what Gina said in 2018 about how Diddy treated her. 2018, right? So this is like filling the gaps. And then, of course, she took him back. But this is the letter she submitted to the judge as to why he should grant Diddy bail. My name is Virginia, and I am writing as a person identified as victim 3 in the case. I have known Sean Combs for many years in both a professional and personal capacity. From that experience, I've seen him primarily as a father, a family man, and a businessman. I'm going to make this bigger. And a businessman. Roles that he has always striven to uphold. I provide this letter to share my observations about his character and to respectfully request that the court permit his release on bond while the case proceeds. I acknowledge and respect that Mr. Combs stand accused and that the court must weigh public safety and the integrity of the legal process. She did not write this. She don't even know how to form those types of sentences. And the integrity of the legal process. Girl, please. At the same time, she says, I believe it's important for the court to have a full picture of who he is beyond the allegations. Our relationship, like many, was not always perfect. We experienced ups and downs and mistakes were made, but he was willing to acknowledge his mistakes and make better decisions in the future. Oh, what time in the future? Because that was 2018. And he had that mutual combat with Jane when she left and he came back and he kept whatever. Over the years, it says, over the years that followed, he made visible efforts to become a better person and to address the harm he had caused. By the time our relationship ended, he embodied an energy of love, patience, and gentleness that was markedly different from his past behavior. To my knowledge, he's not been violent for many years and has been committed to being a father first. I am writing because I do not view Mr. Combs as a danger to me or to the community. This is his first criminal case. Lies, that is not true. Throughout the investigation and proceedings, He has been cooperative, respectful, and compliant. He has substantial ties to his family and community, including children who depend on him for emotional and financial support. Granting him bond would allow him to continue caring for his family and fulfilling his responsibilities while still subject to the court's supervision. I want to assure the court that if released, I believe Mr. Combs will adhere to all conditions imposed and will not jeopardize his freedom or the well being of his family. Girl, you're a liar. Allowing him to be at home will also support the healing process for all involved. Who? Does that include you? Does that include you, Miss Thing? It says, I respectfully ask that you consider these factors when deciding his eligibility for release. All right. Y'all think she got paid to write this? I don't think she got paid per se to write this, but I think she settled whatever civil anything she had going on. And I believe her civil had not yet been filed, which means it was being negotiated in the backdrop. And it's alleged from my sources, she absolutely hired an attorney and was navigating some type of a civil claim. Hit that like. Yes, multiple people are saying they believe he was paid off, that she wants to be the new Cassie. She loves money and she loves him. Remember, she also has a daughter, and she doesn't have a talent like in the way that Cassie had a talent, or the way that Jane was historically beautiful and, has wealthy men that are able to take care of her. Gina was just like a regular jugular. In fact, I remember they said that Gina's allowance was only like 5,000. So he gave Jane twice that, 5,000 to Gina and whatever else to Cassie. But I say that to say, like, if you think about it, if you're Gina, after all this hullabaloo, you can't just go back to the Amazon warehouse. You can't just go back to the mall and fold clothes at H&M or the Gucci store. If she's like a saleswoman at the Gucci store or at Saks Fifth Avenue, you can't just go back and have a regular life and work a regular job, at least not right now. You got to wait for a lot of this to die down. So she has probably had to think all that through. And then also think about it. If he's still paying Jane's rent and for Jane's lawyer, he's definitely paying something for Miss Gina. So the question becomes, what trouble could Gina be in now? Well, let's talk about that before we conclude. Put your questions in the chat. It says Jane's over there punching the air. Some people say, okay, Jane's punching the air. Yeah, she just can't be at Macy's. I'm gonna tell you, if I walk up to her at Macy's, I'd be like, now, victim number 3, where were you? We were counting on you, girl. Somebody said Miss Westmoreland wrote that letter. So here's what could happen. Now, the first question, though, with respect to what trouble Gina could likely be in is, was she subpoenaed or not? There's a difference. There's a distinction. Many people thought that Jane and Cassie were subpoenaed to trial. They were not. In fact, at one point in the testimony, the transcript, they're asked that, and they said, no, I was not subpoenaed. They said, well, why did you come? They said, I wanted to come. I wanted to tell the truth. Generally, you do not subpoena. If it's your key star witness, you don't relegate yourself to someone who's only there as a result of a subpoena. You want someone who's going to be there voluntarily. I say that to say, I don't think Gina was subpoenaed. I think there was an agreement that she was supposed to come. Remember, they kept talking about, we've tried to reach her and her lawyer. We're not getting responses from either her or her attorney, blah, blah, blah. If someone's subpoenaed, the conversation would have been distinctly different. Maureen Comey and her team would have said, Your Honor, we subpoenaed her. The subpoena was served on this date. She has been subpoenaed and we anticipate she's going to be here. The dates on her subpoena require her to be here from this date to this date. And we have no indication that she's not going to come, or we have subpoenaed her and she has not responded to follow-up calls to confirm that she will be complying with the subpoena. So that's important, because if she's not subpoenaed, then she cannot be held in contempt. And she cannot be, which is where the judge would bring her in and could literally jail her to ask her, where were you? Why didn't you show up? Blah, blah, blah. And remember, I told y'all before, and some people were disagreeing. I had said, I don't think they're going to subpoena her. I think they want her to voluntarily come, because what you don't want is someone to get on the stand and say what she said in this doggone letter. Oh, yeah, well, what I said on Tasha K, I was upset. I wanted money, or whatever she says. It says, does immunity extend to charges that can be brought out of civil suit? No. Criminal immunity does not extend to anything civil. That's how come some of these S workers have now sued Cassie in addition to Diddy. There's one guy, Clayton Howard, I believe, sued Diddy and Cassie, claiming that they gave him an STD, and they are able to do that even if there was immunity. Says that makes her letter intentionally misleading to the court. He would have been better off with letters from family, mom, and kids. That letter was, but he must have wanted. See, here's what that letter sets up. Gina's letter helps set up a pardon. Remember we talked about that? I believe it helps support that, because that could go towards the narrative of the government is railroading this successful Black man, that these charges are bogus, that he should not be charged in the first place, that the government has railroaded him by actually taking victim 3, trying to force her to testify against him. She held her own. She didn't show up. She did not state the so-called lies that the government wanted her to state. And in turn, she's submitting this letter that is quite the contrary. You see, those things support, potentially could support a pardon. It says, so why wasn't KK, D-Rock, and Gina subpoenaed? Y'all, we just talked about that. All right, somebody in the chat, help me. They're on a talking tour. That's correct. That's correct. You need a media tour. You need a talking tour to get to a Trump. Because the way that the pardons work is there's actually a pardon department. He don't read. That man don't read. He don't read nothing. And that his staff has actually been upset about that for years, that they'll give him documents and he'll be like, what does it say? What happens is you submit your bail package to the pardon department, and then the pardon department makes a recommendation to him and he just signs them. But this is important, y'all. So the question is, so why wasn't KK, D-Rock, and Gina subpoenaed? So I covered this. You might be joining us a little bit late, but I covered this before. KK and D-Rock were not subpoenaed because you don't put somebody on the stand without knowing their responses to a question. A lawyer, law school 101, and it's okay. You probably didn't go to law school. No problem. You didn't know that. But law school 101 is you never ask a witness a question you don't already know the answer to. And it's not just the answer to, you may know the truth, but you also want to know, how are they going to respond? For example, are they going to lie? If they're going to lie, then you can set them up for that lie in the way that Nicole Westmoreland set up the girl that was Christina Bongelin. I don't believe it was a lie, but where she got the date all mixed up about being dangled. So KK and D-Rock were not called to the stand because wisely, their lawyers never let them sit down with the feds. Because they didn't talk to the feds didn't know what they were going to say. Remember, you never talk to the feds, you never talk to cops without your lawyer being there. And if your lawyer says, I don't think you should talk to them because I don't think it's going to be helpful, I think that they're going to take your words and use it against you, then you don't go talk to nobody. You don't have to talk to the feds. Remember that. Somebody said, I told y'all she was going to get her man. Can we get at least 200 likes before we end this one? It says it could help with a pardon. It says, so I hope that answers your question. Those 3 people were not subpoenaed. Number one, Gina is different. You don't subpoena Gina because she's a key witness. You want key witnesses to be there voluntarily. If they don't want to be there, it's probably because they're going to get up there and say something not helpful. Imagine if Gina had took the stand and said on the stand what she said in that letter. Oh, Jesus, we would have had a whole, no, number one, she would have exposed herself to perjury, but we would have had a whole bigger problem. And then, of course, D-Rock and KK, they were not subpoenaed because they didn't know what they were going to say. So that was a strategic decision. KK had the same attorney. Diddy's legal team was paying, or no, not the legal team, but Diddy was paying for lawyers for those who stated that they needed it. I actually believe that the chef did an interview, and the chef acknowledged that his team, not him, but his team said, well, if you need a lawyer, Diddy will be willing to cover that. As a result, those people, if you know he's paying for your lawyer because you can't afford to do it on your own, where's your loyalty likely going to lie? Exactly. So it says it could help with the pardon since T won't perceive it as a coerced letter. Okay, I could see that. Somebody said Gina is a menace. So number one, It doesn't look like Gina was subpoenaed. Gina was not subpoenaed. Therefore, Gina cannot be held in contempt. She cannot be arrested. That's gamesmanship. So Gina likely had a civil lawyer, and she may have also had a criminal lawyer. So if she had a criminal lawyer, that criminal lawyer likely told Gina, hey, you weren't subpoenaed. You don't have to be there if you don't want to. And she didn't. So it may not have been, she may not have settled with him. It may have just been that because Gina was not subpoenaed, she didn't have to show up. There could be no penalty for not showing up. Is it annoying? Yes. Does it create a hole in the story? There's a huge hole. I mean, to the jury, it seemed crazy that he knocks the snot out of Cassie all the way up until she leaves him in 2018 and does nothing, doesn't lay a finger on Jane until Jane goes co-cocks him on the head. Says Gina is the type of woman that says she's standing on business for her man. Yep. Oh, yeah. But also remember, Gina wrote this letter stating no violence, and then did the Tasha K interview. I'm going to tell y'all right now. The government is going to have a heyday with this letter. This letter is going to be used in whatever final documents that the government submits in support of the sentencing. They are going to cite victim 3. They're going to cite and they're going to say with coercion, Diddy convinced her not to testify. They're going to say that Diddy got her to lie in this submission letter alone. They are going to use this Gina letter to show the power of the coercion, the power of any alleged manipulation, and why it is that they believe, the government believes, that the court should give him the higher end. I don't think that this is not the end of this letter. What do y'all think? If you were on the prosecution, how would you use this letter as the government when you are writing your final motion to the judge for sentencing, trying to get the judge to give the higher end of the spectrum? Yes, the judge referenced. So previously I read the judge's letter. The judge specifically said part of the reason he cannot release Diddy is there was evidence of coercion, violence, and threats, or whatever, coercion, violence, and so forth. And that based on that evidence, under the law, he has to maintain Diddy behind bars until it is time for sentencing. It says, maybe I already answered this, but who approves a retrial? Oh, a retrial would be, it's not an appeal, but you can, so with retrial, first you move for retrial with the current judge. That's what they have currently done. They've moved for this judge to retry the case. And that judge is going to make a ruling. I'm not sure which day it is, but he's giving both sides a chance to respond, and then he'll make a ruling. More than likely, the judge at the regular level will never grant a retrial, because that would be acknowledging something went wrong on his watch. So if he says no, then it gets appealed to what's called the Second Circuit, and then they can make a ruling. And if they say yes, there should be a retrial, then it gets knocked back down. Of course, the government can appeal it to the Supreme Court. But here's what's significant with the retrial. With the retrial, it only allows retrying on the Mann Act charges. They do not get to retry him on the 2 charges he was found not guilty of. Okay? Once you're there, there's double jeopardy. Once you are found not guilty of something, that's it. That's it. So as a result, it wasn't a hung jury. A hung jury is when you can't come to a conclusion on a charge. So as a result, if he chooses a retrial, or if he is granted a retrial on the Mann Act, number one, that jury, it's going to be hard to get a jury that doesn't already have an opinion. But I think that it would be easier for Diddy to get a jury that is pro Diddy than for the government to get an. I also think the government now and who they have in place there, they don't care nothing about this case. They probably would not even retry him. They probably would not retry him. It says, I doubt the judge will give him significant time because the appellate court will definitely reverse it. No, that's not necessarily true in federal court. Federal court is very different So in federal court, it's all about it's the law, the law, the law, and it sticks with the law. So versus state court, them judges in state court be doing whatever. Half of them don't even know, not half of them, but some of them don't even read the law, know the law. They really, half of them really just go by their fear of reelection, of not being able to get reelected. So hit that like button. It says, I thought you could only retry a hung jury. No, anybody can move for a new trial if you feel like it was, if you're convicted. People move for a new trial all the time after getting convicted, right? Some people think that's what a wrongful conviction is, or if someone is arguing they have a wrongful conviction. So anyone who is convicted can move for a new trial, and there's a variety of reasons for that. He is not guilty on the charges that were presented. Sheriff says, yeah, I would definitely roll the dice for a retrial, especially if they're talking about giving him a long sentence. Yeah, that's the key. So the retrial is going to be ruled on by the initial judge sometime. It's more than likely going to be ruled prior to sentencing. I'm going to go ahead and say it'll probably be a no to the retrial. Then it's going to get appealed, blah, blah, blah. What this is doing is it's putting it in the queue so that the appeals court can start making their considerations and ultimately make a verdict. Make a decision. That decision might be next summer. So, all right, drop your questions below, guys. Thanks so much for joining. Share this on Twitter, share this on Facebook, etc. Let me know what topics you want me to cover next. I'm your legal bestie, Attorney Simone, and this girl is that legal. Oh, and to conclude, Gina's not going to jail. Just to let you know, Gina's not going to jail. Pretty much nothing can happen to Gina because she wasn't subpoenaed. If she was subpoenaed, then they could hold her in contempt and a variety of other things. But it looks like that's not the case here. So it looks like Gina might be able to skate and have no ramifications other than the government using Gina's letter to really stick the book at him. Y'all have a great night. It's your legal bestie, Attorney Simone.